Good afternoon. My name is Tim O'Rourke. I think many of you know me. It's good to be back at Westminster Canterbury. I can see some of you in the penthouse, and I know others of you are watching from the safety of your rooms. I trust that you're all well and will continue to be so as we weather this pandemic. But it is good to know that I can interact with some of you today. And Westminster Canterbury, as I've said before, is my favorite class. And so here we go again. Today is the first of a four-part series called Amending the Constitution, Why It's Both Too Hard and Too Easy, and how this fact will influence the outcome of the 2020 presidential election. And so today's lecture discussion will deal with the amendment conundrum, and in subsequent weeks in October, we will deal with equal rights based on sex, electoral college reform, and District of Columbia statehood. And the relevance of these subsequent topics, I think you'll see as we move forward. If you are readers of the Virginian Pilot, you might have noticed a front page story from a week ago. Do you know her? She fought Virginia's poll tax. And it's a feature story on Evelyn Butts, who was a litigant who brought the final nail to the coffin of the poll tax in Virginia, a case that went to the Supreme Court of the United States. Interestingly, and it bears on today's topic, right beside the article on Evelyn Butts is a reference to another story that appears within Trump Makes His Pick for the Supreme Court. Because clearly one of the premier issues of the day is the Supreme Court vacancy occasioned by the untimely death of Justice Ginsburg. Justice Ginsburg served on the court for some 27 years, and her legacy has been celebrated by all people across the political spectrum. If we could see that picture of Justice Ginsburg. This shows Justice Ginsburg at her nomination hearing back in 1993. She was subsequently confirmed by a vote of 96-3. But let me return to the Virginia poll tax case, which came to the Supreme Court in 1996. The headline case was Harper versus Virginia Board of Elections, but the case was paired with Butts versus Harrison, governor of Virginia, and that reflects the important role of Evelyn Butts in making this case through the legal process. I want to draw your attention to the different opinions in this case, and I should say at the beginning that the poll tax had already been the subject of the constitutional amendment. The 24th Amendment of the Constitution banned the poll tax in federal elections, but left the poll tax in state elections untouched. And by the time the Harper case came to the Supreme Court, a mere 2 years later, there were only 4 states that had a poll tax. And for many of you are familiar with it, but essentially the poll tax required that you pay a fee in order to be eligible to vote. And in Virginia, the poll tax was cumulative, so you not only had to pay for the current year, but you had to pay back 2 years, so it was a 3-year tax. Not a lot of money, but clearly a barrier to the vote. And the court, in a 6-3 vote, declared the poll tax to be a violation of the 14th Amendment guarantee of equal protection. So they begin with a kind of irony in that we had a constitutional amendment to ban the poll tax in federal elections, and a Supreme Court decision, one might say a mere decision, was sufficient to strike down the poll tax in 4 states that had the poll tax for state elections. But I wanted to focus on the varying views of the justices in this case because they get to the heart of what I see as the conundrum. And if we can go back to the Harper slide, Justice William O. Douglas wrote for a 6-member majority, and I've just taken snippets of his opinion, but he says, "We conclude that a state violates the Equal Protection Clause whenever it makes the affluence of the voter or payment of any fee an electoral standard. In other words, the Equal Protection Clause includes an element of protection against income-based distinctions, and the poll tax was such a distinction, one that affected a fundamental right to vote. Douglas went on to say, because the poll tax had been around for some time, and you'll see this in Justice Black's dissent, but Douglas went on to say, the Equal Protection Clause is not shackled to the political theory of a particular era. Justice Black wrote a stinging dissent, and he began by noting that since he had come onto the court in the late 1930s, the court had twice, in 1939 and 1951, considered challenges to the poll tax, and in both instances rejected the claim that the poll tax was unconstitutional. And so Black wrote, since the 1939 and 1951 cases were decided, the federal Constitution has not been amended in the only way it can constitutionally have been, as provided in Article 5 of the Constitution. Black goes on, if basic changes in the Constitution are needed, I prefer to let those changes be made by amendment. For the court to undertake that task amounts to an exercise of power the Constitution makers with foresight and wisdom refuse to give to the judicial branch. Court's justification apparently based on the belief that for the court to be bound by the original meaning of the Constitution is an intolerable and debilitating evil. And then Black goes on to suggest that the people know how to amend the Constitution in the formal way, and indeed they just adopted the 24th Amendment. And then Black adds as well that in his view, Congress could invoke its power to enforce the equal protection of the clause of the 14th Amendment by appropriate legislation by passing a law that would strike down the poll tax. He says, I have no doubt at all that Congress has the power under Section 5 of the 14th Amendment to abolish the poll tax if it believes that it is being used to deny voters equal protection of the laws. So this is a case that deals fundamentally with the question of how we change the Constitution, and Black is arguing it should be changed by constitutional amendment, not by court decision. This view is echoed by Justice John Marshall Harlan, who also dissents along with Potter Stewart. Harlan writes, the final demise of state poll taxes is perhaps in itself not of great moment. And he mentions the fact that only 4 states have a poll tax. But the fact that the coup de grace has been administered by this court instead of being left to the affected states or to the federal political process should be a matter of continuing concern to all interested in maintaining the proper role of this tribunal under our scheme of government. So the case really raises the question, how do we change the Constitution? Is it by formal amendment, or is it by judicial interpretation or other actions by the different branches of government? The same kind of question, in a way, is hinted at in Frontiero versus Richardson, 1973. This is an important case in terms of equality based on sex under the Constitution, because it was one of the early decisions of the court to strike down discrimination on account of sex. And I don't want to dwell on the facts at length, but essentially the armed services had a rule that provided for a dependent allowance, and it was automatically given to the wives of service people, but not automatically given to the husbands of service people. And women serving in the armed forces had to demonstrate that their husbands were in fact dependent. And in this particular case, the servicewoman's claim was rejected. And the court, by an 8-1 vote, agreed that this was in fact discriminatory. It violated due process under the Fifth Amendment, since it was a federal law. But and it was notable in several different ways. It was the first case argued before the Supreme Court by then Attorney Ruth Bader Ginsburg. But it's interesting how the court divided on the question. If we can see the Frontiero slide. There we go. So on the far left, the orange marking denotes the appearance of Ruth Bader Ginsburg, and then in the middle, the plurality opinion by Justice Brennan. A plurality opinion meaning it was only joined by 3 other justices. And essentially, Justice Brennan believed and made the argument that any discrimination based on sex was presumptively unconstitutional, and he cited in part for the authority that the Congress had recently put before the states the Equal Rights Amendment. And so we didn't have the Equal Rights Amendment, but the fact that Congress had considered the Equal Rights Amendment was, for Justice Brennan, a signal that society was changing and that the court ought to move along with it. Interestingly, Justice Powell writes a concurring opinion and agrees that this practice in question is discriminatory, but Justice Powell says before we kind of lay down a clear rule of law, maybe we should wait and see what happens to the Equal Rights Amendment, because it's now before the states, before ratification, and the passage and ratification of the Equal Rights Amendment will resolve the legal questions. Well, to make a long story short, and I'll pick this up next week, essentially we have gotten the protections that would have been afforded by the Equal Rights Amendment, but needless to say, we didn't get the amendment. And so we have witnessed through judicial interpretation of existing provisions of the Constitution the achievement of the aims of the Equal Rights Amendment without the formal amendment itself. And so, again, this is the amendment conundrum, and let me state it. The formal process for amending the Constitution has fallen into disuse because it is regarded, rightly or wrongly, as too difficult. And instead, the Supreme Court interpretation of the Constitution has become the preferred method, although it's not the only vehicle for changing the Constitution. It's easier to change a seat on the Supreme Court than to add an amendment. This fact inflames the politics of filling vacancies on the court. We're seeing that right now. But it also leads to fundamental dislocations in the constitutional structure. And these dislocations both reduce and enlarge the powers of the President and the Congress. In the case of Congress, some people say Congress doesn't bother to deal with some problems because it can leave the resolution of those problems to litigation that ultimately reaches and is decided by the Supreme Court. So at the same time, they diminish the role the framers expected we, the people, to play in the process of constitutional development and change. And I prepared a simple chart that looks at recent constitutional amendments. It's interesting. The 23rd Amendment was proposed June 16, 1960, and roughly a year later, it was ratified. And the 23rd Amendment, you'll recall, gives voters in the District of Columbia three electoral votes in the contest for the presidency. The 24th Amendment, as we've already seen, bans the poll tax in federal elections, proposed in 1962, ratified by the states 1964. 25th Amendment, proposed in 1965 and ratified 2 years later. And that amendment, of course, is now under discussion as President Trump inhabits Walter Reed temporarily, we hope, and will be back to the White House soon enough. But 25th Amendment was spawned by the assassination of President Kennedy in 1963. The 26th Amendment, remarkably, proposed in March 23, 1971, and several months later ratified. And that was stimulated by the thought, old enough to fight, and the country was at war in Vietnam, old enough to vote. 27th Amendment is quite an anomaly. It was proposed in September 25th, 1789. That's not a misprint. Ratified May 7th, 1992, more than 200 years later, and I'll return to that at another time. Equal Rights Amendment, which was before the states when Frontiero versus Richardson was decided, was proposed in March 1972. It arguably has never been ratified. Virginia would have been the 38th state to ratify and did so earlier this year, but the Equal Rights Amendment had originally a 7-year time limit for ratification. That passed. It was extended by another 3 years, and that passed. And so even Justice Ginsburg has commented that she thinks that the Equal Rights Amendment is no longer in play. And so she suggested before her death that if we were to have an Equal Rights Amendment, the process would have to start again. And finally, a proposal to give the District of Columbia representation in the House and Senate as if it were a state was proposed in 1978. That wasn't ratified. The 7-year time limit ran out. So this raises the question of what would the framers think about the current state of the amendment process, but more importantly, how did they view the amendment process in its own time? And I begin with the Articles of Confederation, which in a sense was the first constitution for the country, adopted during the Revolutionary War. And Article 13 of the Articles of Confederation contained this language. Every state shall abide by the determination of the United States and Congress assembled on all questions which by this confederation are submitted to them. And the articles of this confederation shall be inviolably observed by every state, and the union shall be perpetual. Nor shall any alteration of any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States and be afterwards confirmed by the legislatures of every state. What does this mean? Well, in short, the Articles of Confederation could only be changed by the unanimous consent of every state. And during the 1780s, efforts to change the Articles of Confederation to deal with a looming crisis in the operation of the new country failed because of the unanimity rule. At one point, it was Rhode Island. Another point, it was New York. And so leading framers such as Madison and Washington looked for a way around the Articles of Confederation. And so this led, of course, to the Philadelphia Convention, which proposed a new form of government. And perhaps the article of the Constitution which is least discussed is in some ways the most consequential of the articles in the original Constitution. And it's Article 7, which says that the ratification of the conventions of 9 states, not 13, shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. And one writer has called this the genius of Article 7, because unanimity was the rule that prevented any fundamental change in the Articles, and with the Constitution, Article 7 provided that 9 states would be sufficient. And this was debated at the Philadelphia Convention, and there were some delegates who said, we need to stick by the unanimity rule, but there were other delegates who said, we're not there now, because Rhode Island had refused to send delegates to the Philadelphia Convention. And when the Constitution emerged from Philadelphia, Anti-Federalists, and now I'm reading from Michael Klarman, Anti-Federalists frequently charged that both the Constitutional Convention itself and its handiwork, the Constitution, were illegitimate. In other words, the Anti-Federalists said the Constitution is unconstitutional because it violates the Articles, and it could proceed with less than a unanimous vote. And then so but as others observed, the fact that Rhode Island itself refused to attend the convention meant that from the beginning they did not have unanimity. And the only way that a new document could be promulgated was to change the terms of ratification. And so the genius of Article 7 was to essentially make a more malleable constitutional form. And as you know, the Constitution was ratified. And this is a celebration of Virginia's ratification of the Constitution, and the leading figures at that Constitutional Convention, which met in Richmond in June of 1788. Madison, of course, was the driving force behind ratification. Mason and Henry were opponents of the Constitution. They wanted to have a second convention to fix it, and they also claimed that the Constitution needed a Bill of Rights. But Henry, I should mention, also argued that the meeting in Philadelphia was illegitimate, an argument ultimately that failed. And so let's talk then about the process that the Constitution provides for amending the Constitution. This appears in Article 5. And the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments, or on the application of 2/3 of the several states shall call a convention for proposing amendment, which shall be valid to all intents and purposes when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof. And then a passage that's often forgotten about Article 5 at the very end, provided that no state without its consent shall be deprived of its equal suffrage in the Senate. And this seems to be, arguably, the one passage in the Constitution that might not be subject to future amendment, or perhaps better said, subject to future litigation. So what does this process actually look like? This chart shows that amendments have to go through 2 stages, proposal and ratification. And all of the amendments so far added to the Constitution have been proposed by 2/3 vote of the House and the Senate. The President has no role in this. And then amendments can either be sent to the states and have to be ratified by 3/4 of the state legislatures, or they can be sent to the states to be ratified by specially elected conventions. Only one amendment, the 21st, which repealed prohibition, has followed ratification by state conventions. Alternatively, 2/3 of the states could petition Congress to call a constitutional convention, and we don't know how this would work because it's never happened. We've come close on 2 occasions to having the requisite 2/3 of the states petition Congress. It happened in the 1960s when 32 states petitioned Congress to call a convention to alter the one-person, one-vote rule that the Supreme Court had promulgated. And it happened again in the 80s and the early 90s when states petitioned Congress, again falling 2 states short of the 2/3 rule, to adopt a balanced budget amendment. So we don't know how the second part would work, but presumably what the framers intended is some amendments could emanate from the top, from Congress, but other amendments could be generated from the grassroots, and we haven't seen the grassroots part of this. Based on the early experience of the framers, it would seem that the Constitution was easy, that they anticipated that the Constitution would be easy to amend. It was a letter that Gouverneur Morris, one of the key delegates at Philadelphia, wrote some years after the convention, and he said, "Surrounded by difficulties, we did the best we could, leaving it to those who would come after us to take counsel from experience and exercise prudently the power of amendment which we had provided." The Bill of Rights was proposed in the first year that Congress met under the Constitution in 1789, and it was ratified in 1791. In 1795, another amendment was approved. And yet in 1804, another amendment. So by 1804, 12 amendments had been added to the Constitution, and based on this experience, not one could expect that the founders thought that the amendment process would be demanding, but surmountable. And in fact, in the early years of the new government, the amendment process seemed to work very well. But we wouldn't get another amendment between 1804 until 1865. And if we look at the comments of and experience of Thomas Jefferson, we get some insight into the contending theories on constitutional change, and this kind of mixed approach to the process of constitutional change based on his own views and on his own political activities. And so he wrote to Madison in September of 1789 on the general subject of constitutions, and he said, "No society can make a perpetual constitution or even a perpetual law. The earth belongs always to the living generation. Every constitution then and every law naturally expires at the end of 19 years. If it be in force longer, it is an act of force and not of right." So Jefferson, who sometimes got a little loose-lipped in his political theories, was proposing essentially that we would have a new constitution roughly every 20 years. When the convention finished its work at Philadelphia in 1787, Madison sent a copy of the proposed constitution to Jefferson, and Jefferson said, as an older man advising his younger student, he said, "Well, there are a lot of things I like about the Constitution, including the separation of powers. Now let me tell you what I don't like." What he didn't like is the Constitution had no Bill of Rights, and he said, "A Bill of Rights is what the people are entitled to against every government on earth, and what no just government should refuse or rest on inferences." And so Jefferson was one voice among many, and an early voice, calling for the addition of the Bill of Rights to the Constitution. The election of 1800 was pivotal in the evolution of the Constitution. Jefferson says this in a later letter to Spencer Roane, written in 1819. He said, "This was as real a revolution in the principles of our government as that of 1776. In its form, not affected indeed by the sword, but by the rational and peaceable instrument of reform, the suffrage of the people." And what happened in 1800, of course, is that the Republican Party, or the Democratic Republicans as they were sometimes known, of Jefferson and Madison, replaced the Federalists. And so we had a smooth transition of power, but not without a major bump, because the original constitutional design provided that the Electoral College, the presidential electors, would cast 2 votes for president and vice president, and that resulted in a tie between Jefferson and his running mate, Aaron Burr. And that sent the election to the House of Representatives, in which each state has 1 vote in the selection of president, and it was only after 36 ballots that Jefferson was elected president. And this led to the 12th Amendment, 1804, that provided that henceforth the Electoral College would ballot separately on the offices of president and vice president. And for all of the turmoil associated with the Electoral College and electoral votes that we'll consider in the 4th lecture, this is the only constitutional change that has been made to the Electoral College. In 1803, case reached the Supreme Court of the United States, with which many of you are familiar, Marbury versus Madison, and the case dealt with the refusal of the Jefferson administration to deliver some judicial appointments that the outgoing Adams administration had made at the last instant. And Chief Justice Marshall, one of Adams' appointees, held that it was wrong for the Jefferson administration to withhold the appointment to Marbury, but at the same time, the law under which the court might address that injustice was unconstitutional. And Marbury versus Madison stands for the proposition that the court can undertake judicial review, laying statutes alongside the Constitution and declaring those statutes that are inconsistent with the Constitution unconstitutional. Jefferson didn't like Marshall, he didn't like this decision, and his views are summarized 20 years later in a letter to William Charles Jarvis. You seem to consider the judges the ultimate arbiters of constitutional questions, Jefferson wrote. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. Their power is the more dangerous as they are in office for life and not responsible to the elective control. And so this is Jefferson's sort of brief against the power of the Supreme Court to undertake judicial review. Obviously, history has refuted Jefferson's view, but it's a view that it infuses a contemporary debate about the role of the court. And finally, the Louisiana Purchase. Same year as Marbury versus Madison, to my thinking, far more consequential in the life of this country. Jefferson wrote in the year of the Louisiana Purchase, the treaty must, of course, be laid before both houses of Congress because both houses had a role in implementing the treaty. Then he went on to say, but I suppose they must then appeal to the nation for an additional article to the Constitution, approving and confirming an act which the nation had not previously authorized. Jefferson, when he undertook to buy Louisiana, basically half a continent, thought that there was no provision of the Constitution which allowed it. And so in thinking about the purchase, he drafted 3 different versions of a constitutional amendment that he thought could be added to the Constitution almost certainly after the fact. And in the event, Jefferson thought better of that because, what if you buy Louisiana and the constitutional amendment is not approved by Congress or ratified by the states? Where does that leave you? And so basically Jefferson just bought it and let it go, abandoning the amendment process. And this leads to one of the most telling observations, I think, in all of American history. This comes from Frederick Jackson Turner, a leading historian in the early 20th century, and he writes about the Louisiana Purchase, the effect of bringing political unity to the Mississippi Valley by the Louisiana Purchase was profound. It was the decisive step of the United States on an independent career as a world power. The acquisitions of Florida, Texas, and the far west followed naturally. Not only was the nation set on an independent path in foreign relations, its political system was revolutionized, for the Mississippi Valley was now opened the way for adding state after state, swamping the New England section and its federalism. The doctrine, this is the glorious part here, the doctrine of strict construction had received a fatal blow at the hands of its own prophet. You might recall that in the early years of the Washington administration, Alexander Hamilton was Secretary of State of Treasury, Jefferson was Secretary of State, and Hamilton proposed to create a national bank. Jefferson said, I read the Constitution, there's nothing in there about a bank. And Hamilton says, yes, but we can coin money and we can regulate commerce and we have necessary and proper. Jefferson said, if it's not in there in writing, it doesn't count. And so in the case of the Louisiana Purchase, Jefferson's initial reading was the Constitution doesn't allow it, but he did it. And so this leads us to note the different ways the Constitution can change. And one, of course, formal amendments. Second is Supreme Court interpretation. A third is congressional legislation, and we'll see this next week when we look at equal rights under the law as it relates to sex. Presidential initiatives, like the Louisiana Purchase, and powers of presidents have been expanded dramatically during wartime or during times of pandemic. Actions by bureaucratic agencies. And finally, evolving practices in the electoral arena. The framers didn't anticipate the birth and operation of political parties. That all changed in 1800, and of course, Jefferson had a major part in that. This chart shows formal amendments by decade, and you see, again, as I've noted, that in From 1791 to 1800, there were 11 amendments. The 12th Amendment came along in 1804, then a long dry spell until what I'm calling the Civil Rights Amendment. 13th, 14th, and 15th. 13th banned slavery. The 14th, equal protection. The 15th Amendment prohibited denial of the right to vote on account of race. And then a series of amendments much later, in the early part of the 20th century. I'm calling them progressive amendments. The 16th Amendment, Income Tax Amendment, 17th Amendment, direct election of senators, 18th Amendment, Prohibition, which had a kind of progressive twist to it, and the 19th Amendment, women's right to vote. In the decade 1931 to 1940, again, a series of small amendments, 20th Amendment, that eliminated the lame duck Congress, 21st Amendment relating to repealing prohibition, and the 22nd Amendment actually came along in 1951, mandated a two-term limit for the president. And then we had a series of amendments between 1961 and 1971, mostly dealing with voting. 23rd Amendment I've discussed relating to electoral votes for D.C., 24th Amendment, poll tax, the 26th Amendment, 18-year-old vote, and the 25th Amendment, presidential disability. And then we have this relic, the 27th Amendment, which was actually added 1992. A student, an undergraduate student at the University of Texas during the 1980s, during the time that the country was celebrating the bicentennial of the Constitution, noticed that originally Congress had proposed in 1789 12 amendments. The first two had not been ratified. What we now call the First Amendment was actually third on the list, and as students suggested that the Second Amendment dealing with compensation of Congress could still be ratified because there was no term limit. To make a long story short, there was a national movement, and this amendment, which seemed to have very little consequence constitutionally, was ratified in 1992. But it's clear that we have not availed ourselves of the amendment process really for the last 50 years, and most of the amendments deal with fairly narrow subjects. The most consequential amendment historically, apart from the Bill of Rights, has been the 14th Amendment. Interestingly, during all this time, there have been only 6 amendments that have passed Congress, that is, achieved a 2/3 vote, and have failed of ratification. And one was the First Amendment on this list of 12 in 1789. A second one was related to a requirement that citizens who held foreign titles would forfeit their citizenship. A third, quite curiously, was an amendment proposed in 1861 that would have prohibited Congress from acting to limit slavery. And this was an effort to keep the southern states from seceding. Obviously, it didn't work, and in any case was contravened by the 13th Amendment. Another amendment would have given Congress authority to regulate child labor. That was essentially superseded by subsequent Supreme Court decisions and the expansion of congressional power. And then I mentioned the Equal Rights Amendment, to which we'll come back next week, and the proposal for representation for the District of Columbia. Now, it's often overlooked that we have 2 separate constitutional experiences in this country. We have the federal Constitution, and when people think about the Constitution, they mostly think about the federal Constitution. But each of the states has a Constitution, and the state, in some instances, the state constitutional experience is longer than the federal one. State constitutions are generally quite long, much longer than the federal Constitution, and thus I note the size matters. And I've shown state constitutions and the federal constitutions. I've lived in a number of states, and I'll come back to that. The most bulky of the states' constitutions is the Missouri Constitution, alongside the federal Constitution. And, things I used to teach my students, many of you are of my generation where you watched a lot of TV westerns. And there were invariably, if you watch one show long enough, there would be one about the crusading minister who came into the town to bring peace to an otherwise violent existence. And invariably somebody would shoot the preacher and he would be saved by a Bible in his breast pocket. And so I used to tell students that the U.S. Constitution wouldn't stop a bullet, but the Missouri Constitution would. And I mention that because I had some students, I swear, who learned nothing in my state government course except the bullet stopping capability of the Missouri Constitution. So here's a chart that shows state constitutions by state, and you can see that many of the states have had more than one constitution. Louisiana's had 11, Virginia's had 6. Interestingly, notably, all states but Delaware require voters to approve constitutional amendments. And 18 states enable voters to initiate constitutional amendments. And 14 states have what is sometimes called a Jeffersonian provision. Remember I said Jefferson said that we need a new constitution every 19 years? Well, in Missouri, where I used to live, Missouri had a provision that requires that the state put to the voters every 20 years the question of whether they will call a constitutional convention to revise the Constitution. Number of words of the Constitution, as you might expect based on the pictures, state constitutions are typically longer. The Missouri Constitution, a lot longer. The Virginia Constitution, closer in length to the U.S. Constitution, but still quite a bit longer. Why? State constitutions are longer because many of them are newer. The Virginia Constitution came into effect in 1971, the most recent of 6. They've been updated. They're easier to amend, obviously. They cover more subjects like local government, education, often the environment. State Supreme Courts are less activist than the U.S. Supreme Court, and so the courts are not a reliable vehicle for constitutional change. And the detail in state constitutions invites further detail. And the length of the U.S. Constitution really is deceptive because you can't understand the Constitution of the United States without knowing what's in the hundreds of volumes of Supreme Court interpretation. And this is a chart that shows number of constitutional amendments for various state constitutions. And somehow my Virginia document has dropped out of that, but you can see that the current South Carolina Constitution has had 500 amendments, the Missouri Constitution 126, Maryland 233. In the current Virginia ballot, we have 2 constitutional amendments, and it's fairly common in any of the states where I've lived that every couple of years you'll be presented with the question of voting on a constitutional amendment. And you see a picture there of a riverboat. You might say, why is that there? My favorite constitutional experience is that the voters of Missouri in the early 1990s approved an amendment that allowed riverboat gambling on the Mississippi and Missouri rivers. And this was sold as a kind of historic cultural thing, a revival of the Mark Twain experience. And this proved to be problematic because it wasn't very profitable. Essentially, the riverboat would dock, a group of people would get on, they'd go out and float in the river for 2 hours and then come back. A different group of people would get on the boat and go out for 2 hours. And gambling facilities are in the business of making money. So some genius came up with the idea of digging a ditch that would allow water to flow into a moat that would then go under a building that would be 1,000 feet away from the riverbank. This was called a boat and moat. And the Supreme Court of Missouri was called upon to rule on this question, and the Missouri court said, well, on the river means on the river. And so boats and moats were ruled unconstitutional, but the casinos organized a citizens' initiative that put on the ballot the amendment that allows, and I should read this, I love this. The General Assembly is authorized to permit upon the Mississippi and Missouri rivers only, which shall include artificial spaces that contain water and that are within 1,000 feet of the closest edge of the main channel of either of those rivers, in games of chance. So oftentimes when we think about the Constitution, we say, and we think about American politics, we say, is it democratic? And with regard to the election of the president, the common critique is the popular vote doesn't elect the president. We'll come back to that. And the question, the equal representation in the Senate is not democratic because California has about 40 million people, Delaware has about 1 million. But it's not democratic to allow 9 justices to decide the meaning of the Constitution. And so this question of the role of the court is tied up in what we expect of our Constitution in terms of democracy. It's also snared in the question of what elements of government can be determined by unelected officials, neither accountable to the president or to the Congress, and outside the courts. Best example here is the Federal Reserve Board. But there are other bureaucratic agencies that are involved in lawmaking and constitution changing, and a notable recent book argues that administrative law, as we've known it, is not lawful. This is the Philip Hamburger book. Given the difficulty of constitutional change, you might wonder, does anybody think about it? And the answer is yes. There are very serious, eminent scholars who have considered major changes to the Constitution. In the 1980s, as the country undertook the bicentennial of the Constitution, James Sundquist, political scientist at the Brookings Institution, proposed a series of reforms that would have been achieved through a constitutional amendment, primarily to bring about greater coordination of policy making between the President and the Congress. More recently, 2008, the well-known Virginia political scientist Larry Sabato wrote a book called A More Perfect Constitution, Why the Constitution Must Be Revised, Ideas to Inspire a New Generation. And I'll return to this book later. It's enough to say now that Sabato, who is a big thinker, actually proposes a new constitution and recommends a series of fundamental changes in the constitutional design, and essentially says, if the founders can do it, why can't we? A book that I much admire by the late historian Edmund Morgan is called Inventing the People, The Rise of Popular Sovereignty in England and America. And it's a somewhat complex and theoretical book. But when we talk about we the people, government of the people, by the people, for the people, we all subscribe to that, but then if you say, well, what does that mean? We struggle. And so let me read this passage from Morgan and then comment on it briefly. Government requires make-believe. Make-believe that people have a voice, or make-believe that the representatives of the people are the people. Make-believe that the governors are the servants of the people. Make-believe that all men are equal. It's a little uncomfortable to acknowledge that we rely so heavily on what he calls fictions. We may proclaim them as self-evident truths, and that designation is not inappropriate, for it implies a commitment to them and at the same time protects them from challenge. Among the fictions we accept today as self-evident are those that Thomas Jefferson enshrined in the Declaration of Independence, that all men are created equal and they owe their obedience to government only if it's their own agent deriving its authority from their consent. It would be difficult, if not impossible, to demonstrate these propositions by factual evidence. But self-evident propositions are not debatable, and to challenge them would rend the fabric of society. And so here's what I think emerges from Morgan's commentary. None of us were around to ratify the Constitution, to approve it, to vote on it, as we have voted on constitutional amendments in our state constitutions. And none of us have actually voted on federal constitutional amendments adopted in our own time. And so it's a stretch to say that we have, as a people, we the people, adopted, approved the Constitution. Yes, you can say, well, if we go to the polls and we vote for congressmen and senators and the president, that in some sense we have endorsed the government and we have approved the Constitution. But it's a stretch, and that's what Morgan is talking about. And so I think a part of the debate now as about the formal amendment process is that if we're involved in the formal amendment process, the people are more directly involved in constitutional change than if the process is left, say, to the decisions of 9 people on the Supreme Court who inhabit their positions literally for decades and are not in any sense elected. And yet, they claim their authority from the Constitution, which is supposed to embody the sovereignty of the people. And that brings us back to the conundrum. And that is, the formal process for amending the Constitution has fallen into disuse, and constitutional change is either accomplished by the court or by actions of the President, the Congress, the bureaucracy, without regard to the formal amendment process, and I would say without regard to the comprehensive, sweeping, engaging discussion that would accompany the consideration of formal amendments. That's actually what Larry Sabato is talking about in his book. And so here are the big questions that I raised for today, we'll consider in subsequent weeks. Does reliance on the Supreme Court to resolve major political questions relieve or exacerbate political divisions? Can a formal amendment process be revived, or can it be changed to make it more usable? If we lowered the threshold, maybe 2/3 of the states rather than 3/4 of the states ratify amendments, would that make the amendment process more available? Or could we even imagine that we would have a popular referendum to approve amendments? Most countries provide for a popular amendment, a popular referendum in some form. We vote on amendments at the state level, and of course you recall the example of Britain, which voted on Brexit as part of a national referendum. Do the states provide then a blueprint for a better process of constitutional change? Is there a role for the unused Constitutional Convention process in Article 5? Never used. And outside the formal amendment process, are there democratic end runs to change the Constitution? As you'll see in subsequent weeks, there's a plan to change to a national popular vote for president without resort to the formal amendment process. Whether this is a good idea or not, whether it would pass constitutional muster or not, but it is a response to the difficulty of making a formal amendment to the Constitution to change the Electoral College. So these are the things that are on the table, and we have a few minutes left. I would welcome questions that you might have. Any questions? I can see you, and if you raise your hand, I think we can hear you as well, correct? Yes, my eminent producer, Bob Anderson, is nodding yes. Yes, so ask your question, please.
I have a question. I actually have a comment, and I think most people do not realize that we are not a true democracy. We are the Republic of the United States. And I think if you realize that makes somewhat of a difference in your thinking, maybe.
I think that's a good point, that we are a representative democracy, and keep in mind that originally the president was not, currently the president is not directly elected, but originally in most states the voters did not choose the electors who choose the president. And the Senate, of course, was not elected by the people. That was changed by the 17th Amendment. The Senate was elected by the state legislatures. And so I think that's true. That is to say that it's a representative democracy and it has elements of democracy, but also elements of what we might call filtered representation. I think when anyone says that's not democratic, then I want to say, well, what would be democratic? And I think there are very few people who favor a kind of unbridled democracy. So many people, for example, I think support the idea of directly electing the president. Relatively few people advocate having a second convention that presumably would be open to radical changes in the document. I think one of the and so I think your point is well taken, but I think the question is, do we want to become more democratic?
I don't think we'd get anywhere if we did. It's bad enough as it is with all the arguments and everything going on.
I mean, I think a continuing question in any government, but especially in a government in which the people have a substantial role, and they do in this government, is are we looking, what is the tension between a fair process and good outcomes? And so what kinds of process we favor may be influenced by what kind of outcomes we think the process will deliver. And I think clearly one of the reasons some people favor a powerful Supreme Court or even an expanded Supreme Court is they view the Supreme Court as more congenial to the policies that they favor. So that's my answer for now, but I think we can pick this up in subsequent weeks. I appreciate the question. Boy, I really appreciate seeing your faces. I see a few, and I know that the rest of you are out there, and it's just great to be back in a kind of interpersonal way at Westminster Canterbury. So thank you for your attention today, and see you next week.